So we now have 45 participants, and we'll start, Richard and Peter. So I'd like to welcome everybody that's come out into their Zoom land to join us so close to Christmas. We appreciate your time and interest in joining this discussion. My name is Declan Owens. I'm the chair of the Haldane Society of Socialist Lawyers. And I'd just like to give a bit of background about the Society and to introduce our speakers for this evening. So the Haldane Society of Socialist Lawyers was founded in 1930. We have always been a thorn in the side of the British state from the perspective of a socialist analysis of the law. We are independent of any political party. However, we are very proud of our international links and our internationalist socialist perspective. Therefore, whatever party is in power will receive interventions from the Haldane Society from a socialist perspective. And that, of course, has meant over the years that we've intervened in Irish affairs, and we've had strong links and solidarity to those in Ireland who have sought to push forward the agenda of civil rights, human rights, and socialism. And in that respect, I would like to emphasize that we are, exactly as we say, we are socialist lawyers, and we advance a perspective which is that of socialism, and one in which we are proud to do so throughout the decades. So in that respect, I would like to very much welcome Peter Madden of Madden Finucane, solicitors in Belfast, and Richard Harvey, who is a barrister with Garden Court Chambers that are based in London, albeit Richard has very much an international perspective and currently works with Greenpeace International, but has long been an important member of the Haldane Society of Socialist Lawyers and is one of our vice presidents. We have 15 vice presidents and a president and an executive committee of about 40 lawyers. So we have a wide range of interests, and we come together as a collective to use our legal skills for the benefit of society as a whole. So the question that we asked tonight, the fundamental question, is quite loaded. We ask whether is the British government still colluding in the murder of Pat Finucane. We are starting from the assumption that they did. I've got personal experience growing up in Ireland of being aware of the murder of Pat Finucane, being aware of the murder of Rosemary Nelson, and indeed being a child of the Troubles, but also having an awareness of the Loughin Island massacre in my locality, where there was also collusion. So we're not shying away from stating the fact of collusion. We're not shying away from presenting the question in the way in which we presented it. This is a position that the Haldane Society has adopted on the basis of analysis and fact, and we shall continue to support the Finucane family and those in Ireland who pursue justice, and we are very proud to do that. So without further ado, I would like to start off by speaking to Richard, by asking him just a general question for those in the audience who are less aware of Pat, and if you could maybe explain how you came to know Pat and his involvement with the Haldane Society.
Well, thank you very much, Declan, and thank you all of the exec at the Haldane for putting on this very important, much needed discussion this evening. I was first in touch with Pat 40 years ago when we took the first Haldane Society mission to the north of Ireland to examine the impact of emergency legislation, and we ultimately published this booklet as a result of that. He was, I think, the first solicitor in the 6 counties to raise the systematic perversion of justice there, not just as a local, but as an international human rights issue. He practiced in the Diplock courts, representing clients who are being systematically brutalized in Castlereagh and other RUC interrogation centres, and being convicted by biased judges, usually on the sole basis of forced confessions extracted by physical and psychological brutality. He was one of the founders of NIASL, the Northern Ireland Association of Socialist Lawyers, working closely with the Haldane to publicize these injustices. He and I both attended the IADL's 1985 Paris Conference on the right of the people of all Ireland to self-determination. By that time, I was living in New York, working with human rights groups there, some of whom are represented here today. Jonathan Moore, I see in New York, and Mary Pike. And we invited Pat to come and do a speaking tour to highlight the injustices that he was fighting at home. I remember him telling us at the time of the numerous death threats that he had received, but in those days, lawyers were regarded as off limits. The impact he created by internationalizing the struggle for human rights in the North marked him as a threat to British intelligence assets and loyalist agents. He was taking one of the most outrageous shoot-to-kill cases in Europe to the European Court of Human Rights on an Article 2 challenge at that time in 1989. Douglas Hogg MP, sheltering behind parliamentary privilege, accused certain solicitors of being too sympathetic to their clients. Everybody in the North knew who he meant. Within a few weeks, the illusion that lawyers had some kind of immunity was shattered by Pat's assassination, and the Article 2 rights that he had been fighting for on behalf of others have been violated ever since in relation to him and his family to this day. A few years before that, a couple of years before that, I had represented the first Irish Republican to gain political asylum in the United States. The case had dragged on for years, with 6-month adjournments between hearings, and Pat was our key witness on the impossibility for many members of the nationalist community to obtain justice. He was our last witness, or so we thought. 2 months later, he was assassinated. I flew over to his funeral, where I first met Michael, his oldest son. I knew the firm of Madden and Finucane, but I'd never met Madden, who I assumed was the sober, elderly partner who plodded on quietly with the conveyancing stuff while Pat was out there running all the risks. What did I know? I flew back to New York, petitioned the judge to reopen my client's case, and I called Peter to tell the court that my client's lawyer had been assassinated. What chance would my client have if he was forced to return to Belfast? My client is thankfully to this day still in New York and has worked tirelessly ever since in support of the campaign for a full inquiry. So 32 years on, I now hand over to Pat's sober elderly partner.
Certainly elderly. I don't know about sober, but I suppose I really should start here at the end, which is the recent decision by Brandon Lewis, Secretary of State, to not hold an inquiry at this time. The decision made 3 weeks ago. And at the moment, the family is now considering what the next steps are in relation to that. But he emphasised that that there will not be an inquiry at this time. But of course, that's just a word phrase that he uses to delay further any decision to have a public inquiry. I think that there will be a public inquiry eventually. I think it's inevitable. I don't know why they're stalling, because they must have everything in place by now to have a public inquiry. So that's the latest decision, and it's the latest challenge I think that we have to consider in relation to that decision. So starting at the end, I think if we sort of move back a bit, just after Pat was murdered, there was an immediate outcry and an immediate call for public inquiry, mainly due to the fact that Richards referred to there Douglas Hogg's statement in the House of Commons 3 weeks prior to that, which was in fact a death notice to Pat, and we knew of that. We also knew of the various threats to kill Pat, the various threats through his clients in Castlereagh mainly, which were the sort of thing that they said to clients were your lawyer's not going to be around much longer, things like that. So we weren't surprised. Of course, I was shocked, totally shocked. The family were shattered, obviously, and the call for a public inquiry has not really diminished since that time, nearly 32 years ago. But there've been a lot of things have happened in that time, and there was a sort of a combination between the campaign. The family mounted a campaign for a public inquiry. That campaign grew in support, and the family took that campaign right across the world. The legal proceedings started almost immediately as well, and there were quite a number of judicial reviews, believe it or not. Brandon Lewis was responding to a Supreme Court judgment which was the result of a judicial review taken just after David Cameron announced a review of the papers by Desmond de Silva. So the case went through the High Court in Belfast, the Court of Appeal in Belfast, and then to the Court of Appeal in London, and the judgment was made on the 27th of February 2019. I think that's the right date. So the judgment itself, I think, is important, and it's an easy to read judgment. It sets out practically the whole history of the legal process. It sets out, it refers to Brian Nelson, the arrest of Brian Nelson, the statements of Brian Nelson, refers also to the FRU, the army unit that ran Nelson as an agent, and we had challenged the De Silva decision, which wasn't. It's very interesting because when the Supreme Court judgment was delivered, some parts of the British media and press portrayed the judgment as a failure, that the case didn't achieve its objective, which was to get a public inquiry. And that wasn't true. This was just another spin from the British establishment in which they tried to portray a failure of a case that was actually succeeded. The family had challenged the Cameron decision to appoint De Silva, and that succeeded. So the judicial review procedure has been used throughout the last 30 years on a number of occasions, and that was the culmination, as I say, of the decision to appoint Desmond de Silva. So I'm not sure. It's a fairly comprehensive. I I suppose in terms of dates, it's a very, very complicated rather than comprehensive. It's a very complicated process. It has been, and it's only when you look back on it now that you see how complex it is. But I suppose if I skip from Nelson and go to the Weston Park agreement between the political parties in the North, British, the two governments, in which the decision was to appoint a judge, an independent judge, who would assess 6 cases, which were representative cases. They were symbolic cases of many hundreds of cases in the North, but these cases were picked out as symbolic for some reason. Certainly wasn't the family's idea to do this, but that's what the two parties, I think, in the North decided, that there would be symbolic cases. Pat's case was one of them. Judge Peter Corey from the Canadian High Court, he's a retired High Court judge. He reviewed the cases, had reviewed the paperwork, and he found that there was merit in Pat's case and there was merit in having a public inquiry. So that started off the public inquiry process, which is that, and Peter Corey gave a ruling, give a report on that in 2004. But we had to take a judicial review even then to get the British government to publish the Corey report, because he finished his work and he sent his report to the British government, and they didn't publish it, and they sat on it for a long time, similar to the way in which the British government here this year, didn't respond to the Supreme Court judgment. So they didn't. They just sat on the Corey report, and then eventually we took a judicial review to force them to publish it, and then they published it. And as I say, Peter Corey recommended the public inquiry. So I'm not sure, how much detail we could spend a lot of time on the detail of this, but I think what is important here, as a result of the Corey report, the British government indicated that they would have a public inquiry, but not until the prosecutions were completed. And the prosecution going at that time, they were prosecuting Ken Barrett, a member of the UDA, who was eventually convicted and convicted of murder. And what happened is that the British government said, we'll wait until these prosecutions are over. Meanwhile, the other cases that were part of Judge Corey's review, they started. So Pat's case was left after Ken Barrett pleaded guilty, and after he was sentenced, then the British government said, well, we'll commence the public inquiry, but not just yet, because we have to put it into a different piece of legislation. So, and that legislation isn't ready yet. And the legislation they were talking about was the Inquiries Act. It turned out to be eventually the Inquiries Act of 2005. I have to say that when Judge Corey made his recommendation, the inquiry that he was envisaging was an inquiry under the Tribunals of Inquiry Act 1921, which was the legislation that established the Bloody Sunday inquiry, for example. And the important point about the new legislation is that it was dressed up as a comprehensive piece of legislation to cover the detail required to hold public inquiry. And in fact, there was an important section 19, that was inserted into that legislation, which actually gave control of the inquiry, of any inquiry under that act, to the government, to the minister, who could issue restriction notices restricting various different various things, including preventing publication of information that was put into the inquiry panel. Even if the panel wanted to publish it, the minister could issue a restriction notice which prevented him from doing that. So that's what you had. You had the new piece of legislation which handed the control of the inquiry from the inquiry chair and panel to the government. And it's particularly egregious in a situation where you've got a case which the government is actually accused. And in Pat's case, the British government were accused of murder and accused of murdering Pat by the use of agents like Brian Nelson to carry out murders and attempted murders, conspiracy to murders. And in Pat's case, the idea that any minister of the British government could actually veto the information that's coming into the panel was anathema to the family, and the family protested about that and refused to cooperate in an inquiry under the Inquiries Act at that time. In fact, Judge Peter Corey wrote a letter just after the Inquiries Act was enacted, and said that he thought the whole idea of it was like an Alice in Wonderland situation, as he described it. And Lord Savile, the Savile inquiry, he wrote a letter saying that he would be advising his judges or his colleagues, his fellow judges, not to take part in it. So maybe I could just stop there, because it goes on quite a bit, and if anybody else wants to sort of come in.
Yes, so Peter, I think, there is so much detail, as you've alluded to, and in recent times we've seen other systemic injustices that have failed to be properly addressed through the inquiry system, arising out of the inadequacies of the 2005 Act. And indeed, the Haldean Society of Socialist Lawyers has decided to have an inquiry into inquiries, which may sound like a contradiction or an overly analytical approach, but we take the opposite view. We take the view that we need a political intervention in this area, because in situations like Grenfell, in situations like the undercover policing inquiry, in which some of our members are instructed, we see the manifestations of the very faults that led you to your conclusion, and which, prevent the proper analysis of the issues in the way that we would see them, certainly as socialist lawyers. And that applies to issues like Grenfell, like Orgreave, and the failure to provide a public inquiry into Orgreave as legitimately demanded by Orgreave Truth and Justice. Also, I think that we must take a socialist analysis to these matters. But Richard, I wanted to bring on the discussion and then ask you to give your views as to why lawyers in Britain should care about this issue, why socialist lawyers should care about this issue, why every citizen should care about this sort of issue.
I think one very simple analogy is between Douglas Hogg in 1989, 1989, God, long ago, and Priti Patel today. These are absolutely criminal attacks on our justice system, and that the Home Secretary should today, backed by the Prime Minister, consider it appropriate to attack lawyers for doing their job, to attack immigration lawyers in particular for doing their job, is just a clear indication that this government thinks itself above the law as much as Douglas Hogg and the government then thought themselves above the law. But I think this is pretty self-explanatory to anybody who, with any interest in the Haldane Society, whether member or not. We are living in times of extreme threat to democratic values. You don't have to be a socialist to recognize the level of hypocrisy that we are surrounded with, and corruption at the highest possible level in the country today, where the friends of the rich and powerful are fine, where we can have limited violations of international law if it suits our purpose. The rule of law is under threat today, I think, as much as ever, and perhaps more than ever.
Thanks, Richard. I think that's right. As the Haldane Society, we've offered solidarity to, firstly, asylum seekers, refugees, and we offer solidarity to their lawyers as well, many of whom are our members. And there is a hostile environment for asylum seekers and refugees in Fortress Britain and in Fortress Europe. We had a conference on the 24th of October where we discussed those issues in the context of climate justice as well, where this situation will continue with climate migration over the years and decades to come. But I'd like to ask Peter, there's a sense where the rule of law is being ignored, and one particular instance of that is the Supreme Court decision in relation to the delay into Pat's assassination. And I wonder if you could give maybe the audience a bit more insight into the Supreme Court decision and subsequent events.
Well, first of all, maybe I could if I just take up where I left off, I think that'll answer the question. In the Inquiries Act, as I mentioned, the family were not going to take part in the Inquiries Act under those circumstances, and there was a stalemate for a while, for a number of years, for 2 or 3 years. There's a stalemate as to what was happening. The family were lobbying, and the campaign continued, and more people were supporting the family. And eventually we got to the stage, having watched other inquiries taking place, that there might be a way in which the family could actually take part in an inquiry if the restrictions that were imposed by the Act were relaxed in some way. So we got into negotiations with the NIO in Belfast, and we held meetings. Our legal team met with their legal team, and they were producing, and this is an interesting point, they were at those meetings, the government people were producing a number of inquiry types, and the idea was they wanted to discuss the various inquiry types. Some had taken place since 2005, and they really wanted to know what we would go with. Would we go with any of those inquiry types under the Act? The Act was there. We couldn't do anything about the Inquiries Act, but there were ways in which the restrictions, for example, could be relaxed in some way. So our view was that what they were actually doing at those meetings were that they were actually setting up a public inquiry, and that the family were being offered a public inquiry, but all you had to do then was just discuss the various inquiries and let us know what you think is the most appropriate inquiry. So we took a view that the Bahamusa inquiry that's the inquiry in London in relation to the brutalities by the British Army in Iraq, and we took the view that because of the protocols that were used in that inquiry, that the family could actually go along with that and improve the position once we got started. So we put that forward, and we said, well, we'll go for the Bahamusa type inquiry. So that was put to their legal team. They reported back to their government people, and then about several months after that, I got a phone call from London, from David Cameron's office, from one of his aides, to say that the Prime Minister has now taken this over and wants to meet the family, wants to meet the Finucane family, and has come to a decision about what he intends to do about Pat's case. So I queried that, and I said, what is the decision? And he wouldn't tell me what the decision was, but he said the family will be happy with the decision. So I reported back, and we all decided that this seems to be good news. And we went over to meet David Cameron and the Secretary of State. At the time, he was in fact the decision maker. Patterson was the decision maker, but Cameron took it over. So we went over to Downing Street, and the whole. I have to say, when he announced that there wouldn't be, he didn't actually say there wouldn't be a public inquiry. What he said was, we're going to have a review of all the papers, all the previous investigations, including the three investigations that John Stevens undertook, including the Corey review papers. And he said, we're going to appoint a senior counsel, a QC, to review all the papers. And I think we were waiting for the punchline, which was, when's the public inquiry going to start? And the punchline didn't come, because there was no intention at that of the Prime Minister at that time to offer a public inquiry, despite the discussions that we had beforehand. And I would sort of term them as negotiations beforehand, but there's no intention to have a public inquiry. And the family, not for the first time and not for the last time, were insulted by the way in which they make their decisions, but it's the way in which they make their decisions, and it's the way in which they communicate their decisions, which I think is very, very offensive. So they had the family all the way over to London to hear this nonsense. And then what happened then was Mr. De Silva then started to conduct his review of the papers, and we all knew that it was just not. It wasn't Article 2 compliant. It was very clear. He had no powers to compel witnesses. He didn't compel witnesses. He asked a few people to come along and talk to him. He didn't compel documents. He asked the various ministries to send him documents, which they did, he says. And then he got other papers which wasn't given to John Stevens, and papers that weren't given to Judge Corey. No explanation for that. And that what happened then was that we immediately took a judicial review, once again, a judicial review of the decision by David Cameron to appoint Desmond De Silva to review the papers. That was the judicial review, and it took quite a while to get through the courts. It went to, as I said, it went to the court in Belfast, the High Court, and then it went to the Court of Appeal in Belfast, and then to the Supreme Court in London. And that's the judgment that's now available, 79-page judgment, which is very, very easy to read. It's set out very clearly as to the various milestones in the case, the milestones in the campaign, the family's campaign, which Lord Brian Kerr, the Lord Justice who delivered the judgment, he referred to it as a relentless campaign. And he started off his judgment by saying that. And it was true, it was relentless. And it's still continuing, because it has to continue. So anyway, the Supreme Court judgment, as you mentioned, Declan, is a good starting point, you know, to find out, you know, to look at Pat's case, because there's not an awful lot of legalese or legal jargon in the judgment. It's very, very factual, and it's a sort of a masterpiece in dates and the various legal processes and developments since Pat was murdered. And it's a good starting point for anybody who wants to know about Pat's case. So we are now in a position where we have got the British government's response to that judgment, which is that there is not going to be an inquiry at this time. So it's just very strange, because they didn't say, you know, we're not going to have an inquiry ever. We simply said it's not the time for an inquiry. And, you know, everybody, I think, certainly I was sort of scratching my head a bit about this, wondering, you know, wondering what exactly that was all about, because I didn't expect it. I was sort of blindsided by that decision. So we're now, so it sets out, the judgment, as you've asked, Declan, sets out the reasons why the British government to this day are not complying with the Article 2 of the Convention. To this day, they haven't complied with Article 2. They continue not to comply with it. And they actually referred to two processes. This is Brandon Lewis, when he was making the decision 3 weeks ago. He referred to two processes which he said had to be conducted before there'd be a decision made about an inquiry, and the two processes really are not relevant to Pat's case at all. It doesn't matter. It doesn't matter whether or not there is a continuation of a police investigation, or whether or not there's a continuation of a police ombudsman investigation. It doesn't matter. Whatever conclusion either come to, they're still in non-compliance with the convention, and those two processes are not going to cure that, because they still have to have witnesses. They have to have powers to compel witnesses, which they don't have, and they have to have powers to compel documents, which they don't have. And the investigation is both investigations are not independent in any shape or form, including if the police decide to get what they call an independent police force in to look at it. It's still not independent. So there are certain requirements set out by the European Court as to what makes any investigation Article 2 compliant, and none of these two processes, when they conclude, are going to make it compliant. So I don't know what's happening there, but the campaign, the family's campaign, continues. We are now looking at the decision, and then we will make a decision as to what is the next step.
Thanks, Peter. I think we must ask the question, as we always do at Haldane, as to the intersection between law and politics. And as I alluded to in my introduction, I met Richard in the context of Rosemary Nelson's murder, if you recall, Richard, and you were campaigning in relation to that back in 1999, but you also met the Finucane family coincidentally whenever I was there with you interning in New York. And I guess the question then becomes, well, what have the British government got to lose by having an inquiry, and what has been the impact on the Irish peace process? And can you give us insight into the international support, including indeed the tacit support of President-elect Joe Biden at various times, and the sort of macro political analysis, please?
Well, certainly the impact in the United States was huge of Pat's assassination. The campaign grew and grew, and the those of us working on that campaign were constantly in communication with members of Congress, and there was Jane Winter in particular came over on a number of occasions and addressed committees of Congress and senators, and there was a constant pressure building and building and building. And of course, we brought over Rosemary Nelson to help highlight the campaign. And she told us about the similar threats that she was receiving. And we thought, well, if there's one way to protect Rosemary, it is by making her so visible a target that she becomes an unhittable target. And we should obviously never underestimate the determination of various aspects of the British security forces, and that's where it comes down to. British intelligence and British security forces, they have operated so far with complete immunity for their crimes in the north of Ireland. And there is no question in my mind, I'm sure in Peter's, I'm sure in that of anybody who's done any kind of investigative work on this period of time, that Rosemary was assassinated again in collaboration with British agents who were, let's be clear, every single member of the squad that attacked and killed Pat, every single one of them was a British agent. The attempt by the government at that time and ever since to say these were loyalist hitmen on a mission of their own is complete rubbish. And everybody who knows anything about it recognizes that. This was something that was designed by very senior intelligence and military sources. And of course, that's what the government has to hide. If that information actually comes into public domain, every single one of those individuals will be given a letter rather than a name. They will be protected at every possible twist and turn from any kind of accounting. And that's, of course, what the government is trying to avoid. So the international pressure is the only way that any kind of justice, and just as Pat felt and said and did at the time, you're not going to change the political system and the lack of justice here if you simply stay at home and complain about it. You've got to internationalize it. And Peter and the family have done the most incredible, dogged, persistent job with huge dignity. And the things that you feel like saying in your mind that they have forborne from saying in public. And at every turn, they have conducted themselves with unbelievable dignity in the face of what Peter has rightly called the insults, the treatment by the British government, by the political class. It beggars belief that they still carry on with this complete denial of justice.
Thanks, Richard. Peter, I guess I'm going to ask what some, maybe all, will recognise as a leading question. Given your involvement in this case, and indeed in others with families, including the Bloody Sunday families, is it the case that there can never be justice in the north of Ireland under British rule? And how do you see your experience as a lawyer through all those years, through the decades, And how do you think we can approach this question?
I think the closest you got to a fact finding and a truth finding exercise was the Savile inquiry. I think it's the closest you've got to that. Lord Savile spent as long as it took to put together the evidence in relation to the murders. I call them murders because they're obviously the conclusion that although he didn't call them, Lord Savile didn't call them murders because he couldn't really do that. He couldn't make a criminal finding, but they were murders in the street, and he set out a wide-ranging inquiry. And it was criticised by many people, and the report was criticised by many people. Some people criticised it, simply because it took so long and it cost so much. But other people criticised it because it was just not the way to find the truth. But nobody has ever actually persuaded me that there's another mechanism where in the Savile inquiry, you can compel witnesses, you can compel the documentation, you can cross-examine the people who made the various statements and prepared the documentation, and it's conducted in such a way that in public, so that the public can make their own decision as to whether or not the truth was found there. But the report found, of course, that Lord Savile found that the young people killed on Bloody Sunday were totally innocent, and David Cameron, prior to Pat's apology, made an apology to the families and the people of Derry for the murders in the street, and made a public apology for that. So, and that's the closest that I know of that which you could possibly get to the truth. And that's why we objected to the Inquiries Act coming in 2005, because it repealed the legislation that held the Bloody Sunday inquiry, and it brought in, as I say, the restrictions. So, I mean, the question is it possible to get justice? Certainly at the moment, I think, if you had to round it up, you'd have to say that it is probably impossible to get justice if the government of a country or of a state are able to veto the truth, or veto the information, prevent the information from being made public, and put a lot of, I suppose, a lot of effort into preventing the truth from coming out. And we see that in all sorts of different cases going on now at the moment. The inquest process is now almost like a mini public inquiry now, although it didn't used to be. But you still see the reluctance to provide the information, the proper information to the parties, to the families, and and you're asking, will people get justice? You'll only get justice when there's a just system in place. You'll only get justice if there's a system in place which allows you to actually get to the bottom of things and get to the truth. Now, at the moment, it's very difficult to do that, but I think that's the only way. I don't want to labour this, but there's one thing I think is important here, and that is the De Silva report, which is 800 pages long. And I think it's important to point out that De Silva was appointed to do a review, and he certainly put a lot of effort into his review. He certainly put a lot of documentation into his report. And people have said to me, what's the problem about De Silva? What's the problem here? He did a very thorough job, and he found that the state agents were involved in Pat's murder and other murders and attempted murders as well. And I said, what's the problem with it? And I said, my view, the problem is that De Silva found that Brian Nelson did not pass information about Pat over to his handlers, into his British Army handlers. De Silva found that as a fact, that Brian Nelson didn't, although Brian Nelson was targeting Pat, it seems, but he didn't pass that information over to his military handlers. That's what De Silva found. The difference in that is that Judge Corey found that he did, in fact, probably hand over the information to his handlers. And that's the whole crux of the case. Because if, for example, if Brian Nelson, who was actually the head, he was the chief intelligence officer for the UDA in the whole, I think it's in North and South, but he was the chief intelligence officer eventually. So he was a top man. And if Brian Nelson didn't pass on the information about Pat, then how could the British Army or the British government be at fault in relation to Pat's murder if they didn't know about it? And that's what he found. And that's really completely, I suppose, incomprehensible to me, how he could find that from the evidence that was there, from the documents that are there. Now, this is the big problem about allowing a paper review like that to be dressed up like a public inquiry. The report was published by the same people who published the Saville report. It looks the same, like a public inquiry report, but it's not a public inquiry, and it wasn't a public inquiry, and it's set on the shelf as if, well, there's another public inquiry we've finished with. There it is. You know, people can read it at their leisure, and that's what happened, and that's the whole truth of the matter. And that's my big problem about De Silva. But I have to say, he did put a lot of documents into the public domain that we didn't know about. He put copies of them into the public domain. Some of them were redacted. But on the other hand, you see, the British government thought that was the end of the matter. So they could afford for De Silva to put some of those documents into the public domain. They could afford it because it wasn't going to go anywhere else. That was the end of it. Review.
Could I just come in for a second and trespass on our moderator's function for a second, because I see a question from an old friend of mine and an old friend of Pat's, Jonathan Moore, in the list here. That given David Cameron's admission that there was British collusion in the death of Pat, if a public inquiry is held, what do you hope will come out of that process? Is there any hope? Is there another way of putting it?
Well, I mean, you have to hope that you'll be permitted to apply proper mechanisms, you know, that will be able to challenge the various let's say the various government's versions of events which you don't agree with. You'd have the opportunity to challenge it, and you'd have the opportunity to call for documentation that you know, that you think is relevant, not that the state thinks is relevant. You think is relevant. So I mean, I think there's a good, certainly a good opportunity there if you had the proper mechanism in place. And the only mechanism, as I say, is a public inquiry. And if there are restrictions, if the restrictions are relaxed in such a way that you can actually compel the witnesses, and you can cross-examine the witnesses, and you can compel the documentation, and you can call people who created the documentation in relation to this, then, you know, there is a chance that you'll get to the truth of the matter. And they'll certainly be able to come to conclusions that are implications, possibly. But I think there's a good enough chance that it is. But I don't think anybody, certainly a family, are not giving up any hope on that.
Thanks.
Thanks, Peter. I think, Richard, what I was keen to explore, you know, for me, it's an important issue, of course, because I come from Ireland. My father was involved in Republican politics, and, you know, there's a certain way in which it impacts me, having grown up in the Troubles and being a lawyer myself. But, you know, for British comrades and indeed lawyers, what should they do? How should they help in this campaign? Because the campaign, as Peter says, goes on.
Richard.
Sorry, I missed the question in there.
Sure. Sorry. So the question is, how can lawyers in Britain who don't have the same interests that, say, I may have or you may have, and obviously those in Ireland who've campaigned, how can they practically help? How can some of the attendees here practically help?
I think, first of all, by familiarising themselves, as everyone is doing tonight, with the present state of affairs, because what has been going on now for these last 32 years has been the British government's response of hoping that they will wear the campaign down, that we will eventually give up and say, well, we did our best, we gave it our best shot, but it's clearly not going anywhere. Frankly, I think the government is just waiting for potential witnesses to die, for old farts like Peter and me to die, and just hoping that we'll eventually shut up and go away one way or another. And so keeping up the pressure, keeping on with our determination, and demonstrating, as has been made so clear by Peter, that inquiries act inquiries aren't inquiries. That this is an and I really salute you and the Haldane, Declan, for putting that one firmly on the agenda as something that we really need to study thoroughly, because these are simply whitewashing jobs, and in many cases blackwashing jobs washed with black ink that prevent you from reading the names, reading the dates, reading the places, so that even the documents that they do give you are relatively worthless. So I tirelessly keeping on the pressure. I know no other way.
Thanks, Richard. Peter, I'm going to invite people to ask questions. I've got some in the Q&A, and I just have one final question before we enter into that phase of tonight's discussion. So, I agree with Richard. Myself and Haldane shall continue to support the family in whatever way we can. And we've got the inquiry into inquiries methodology that we're investigating with a panel of experts, including yourself and Michael Mansfield, Chris Peace, and we are going to investigate that further with Phil Scratton, who did such a great job with the Hillsborough campaign. So the final sort of question for you is, what is the next legal step in terms of the strategy insofar as you can disclose it? What is the next step? Are you looking to go to the European Court of Human Rights on any issue? What can be done there?
Well, I think we're just, at this moment in time, we're just considering Brandon Lewis's decision, and we want to respond to that in a proper way. But he produced 3 weeks ago, for the first time, he produced a 70-page document, which is dated 2015. That's 5 years ago, obviously. And he produced that document, which is a review by the Legacy Investigations Branch of the PSNI of the De Silva judgment. So it's 5 years old. We just saw it 3 weeks ago. And I mean, I just don't understand that. And we're just going to have to sit down and have a discussion. The family are going to have to look at their options and consider the options, and then make a decision. And they'll make a decision as to what the next step will be in terms of an illegal process. And there certainly will be something happening. They're not going to go away, by the way, just
So thanks, Peter. At this stage, I'd like to invite Michael Finucane, Pat's son, to speak if he would like to come on screen. Alternatively, I can ask a question if he types it into the Q&A.
Hello, everyone. Hi, Peter. Hi, Richard.
Hi, Michael.
Hi there, Michael.
I suppose I'd like to just begin by thanking everyone for connecting to the meeting this evening. Even though we're talking about a killing that took place almost 32 years ago, I think what's been made clear from this discussion is that the issues remain important, because the issues recur and the need for scrutiny of government is something that is ever present. The details of the Pat Finucane case have expanded and become more widely known over the years, but in essence they involve a case study, if you like, of how one target was singled out for assassination through the use of a complex and sophisticated web of intelligence gathering, agent management, asset control, and ultimately the aftermath of cleanup and disinformation to allow everybody, including government, to get away with it. Now, if you apply those generalities to situations that we face today, it's not difficult to see the parallels. So if you want to know why it's important to read about the case of Pat Finucane, it's because it applies to what's going on in society today. And it's not even just Irish society or British society. Other modern democracies and not so democratic nations as well employ these tactics. Sometimes they come to light, and sometimes they result in people being held to account. Members of government in Spain have gone to jail over collusion activities with illegal paramilitary groups. FBI agents were prosecuted and I think also imprisoned over their use of agents, including the notorious Whitey Bulger in Boston for many years. And now you have also a situation where the Covert Human Intelligence Sources Bill is making its way through the British Parliament. And all of these cases, and especially the case of Pat Finucane, is a case study and a prime example of why it's necessary to maintain scrutiny. And I suppose if anything good is to come out of the Pat Finucane case and the work that so many people have done on it, is that it provides solid evidence for arguing against the deregulation of covert intelligence sources, of informers and agents, and allowing them to commit crimes in the name of what some people would define as justice. So I think that, for me, explains why we keep doing what we do and why we feel it's important. It's not just for us, and it's not just for the many other people whose cases have not been properly explained and who might get some answers if the collusion process is more widely publicized, but also because of what it can tell us about how we should do things in the future, or more importantly, not do things in the future. So that's really all I have to say on the subject. Peter and Richard have covered it all expertly as ever in their own addresses. But the one thing I want to say just as I finish is, thank you all for the support over so many years. It's not easy to keep going sometimes. The setbacks have been many and are sometimes disheartening, but the support that we get from people all around the world is what keeps you going. And it really does provide a boost. And knowing that it really makes a difference. And we know that because so many people tell us. I live in Dublin, was out doing a little bit of Christmas shopping today. A man stopped me on the street and talked to me for 5-10 minutes about my family's case. Never seen him before, probably never see him again. But that's a regular occurrence for me. It's a regular occurrence for so many of my family. And the wishes are always good, despite what some politicians with vested interests will tell you, and certainly governments will tell you. The overwhelming reaction we get from people is, what you're doing is important. Please keep going. We will support you until you get what you're looking for. And I can't tell you how much of a boost that provides. So thank you all.
Thank you, Michael. Just before I go to other questions, is there anything else you want to ask Peter or Richard, or shall I move on?
No, I think I can safely say that Peter and Richard are sick of me asking them questions for a long number of years. And I think it being Christmas and everything, I really ought to give them a break.
Yes, okay. Well, solidarity
That's time for
to the
everything.
family. Okay, so I have a number of questions in the Q&A. I'll try to get through as many as possible and see how the discussion goes. I think we are planning to end at 8:30, so that's where we are, and we have, you know, a good opportunity to go through the questions. So I'm going to ask a question which, you know, is related. It's one which Haldane is involved in. Indeed, I'll ask the question of Richard, but one of our vice presidents, Gareth Pearce, who many will know, is instructed on behalf of Julian Assange. And Deepa Driver, who is preparing a report on behalf of Haldane as a legal observer at that trial, she asks, well, she says, "Thank you for explicitly pointing out the role and impunity of the intelligence services, Richard. This is definitely something Haldane needs to grapple with. More must be done to highlight, to complete the complete lack of accountability under the guise of national security, which is used as a cover for protecting both the security services and incompetent, irresponsible, malicious politicians, many of whom are corrupt war criminals." And she asks another question, well, that's more of a comment, but her question prior to that was, the British government has been accused by the UN Special Rapporteur of the torture of Julian Assange. The British government has simply ignored its obligations under international law. No inquiry has taken place into these allegations, public or otherwise. Not only were Assange's privileged conversations spied upon, he is currently locked down in solitary in Belmarsh, and as a result of COVID is in a wing with 55 COVID positive prisoners when he has a chronic lung condition. Her view is that the British government is trying to kill him. So in that context, are there any lessons those in the Assange campaign can take from the past 32 years that can be used to free Julian and avoid Julian being killed by the British state?
Well, first of all, I hope it's not going to take 32 years to get justice in his case. But we all know that the present administration has no problem with violating international law, as long as it's in a limited and specific way, of course. I think you can only take this lesson from the Finucane campaign, and that is to continue to intensify the campaign. I wouldn't seek to give advice to those who are acting as legal counsel for Julian Assange, but the determination to silence him is a threat to every form of journalism, and it's a threat to fundamental freedoms of speech, and simply leaving him to rot in conditions which I agree amount to torture. It is psychological torture to keep someone in those conditions without any kind of legal sanction for it. I don't know. I'm exasperated. I've given up on any sense that this government can deliver at all when it comes to human rights, but perhaps others have a more sanguine approach than I do. I don't know what the present state of his case is, and I don't want to sidetrack the discussion of the Finucane case, which is obviously the central issue here, but I would certainly support action by the Haldane Society to demand his immediate and unconditional release from conditions of torture, and that clearly threaten his life at a fundamental level. Those kinds of conditions with 55 plus people already diagnosed as positive. Over.
Thanks, Richard. Peter, do you want to comment on that, or should I move on to the next question?
Well, I don't know the detail of that case, but there's something very wrong about it, and I think if there is an impression that there's something very wrong about it, you'll probably find that there is something wrong about it, and I don't see why anybody can remain in custody in a case like that, because it's not the usual case where you should remain in custody. And I don't know what the bail provisions were, if there were any, but it's a very strange situation, I think, and it's a pretty outrageous situation, actually.
Okay, well, luckily we have Deepa on the case, and she attended the proceedings and will produce a report. So I'd ask attendees to look out for that. The next contribution and question comes from Chris Peace of the Orgreave Truth and Justice Campaign. She says, thanks to Haldane for organising this meeting, and on behalf of the Orgreave Truth and Justice Campaign, I send solidarity to all campaigning for justice for the Finucane family and other campaigns like ours fighting against historic injustices. We submitted a comprehensive legal submission for a public inquiry into Orgreave, but were refused by Amber Rudd, the then Home Secretary, in 2016, before she was disgraced in relation to her handling of the Windrush campaign. That's my aside. A request for an independent panel review was then turned down by Sajid Javid. Whilst we have got a number of files released, we have located ACPO files, police intelligence reports on the miners' strike in Hull University Library, embargoed until 2066. 1,000 years after the Norman invasion, but 2066, 82 years after Orgreave happened. The reason given is because they contained personal sensitive information. Does any of the panel know of any similar cases of papers being embargoed for this length of time for these reasons? So again, it's somewhat of a leading question, but Peter, do you want to take this first?
Well, the embargo situation is an imposition that for many reasons. The main reason is that they use sometimes is that people are still alive who might be criticized by the publication of documents in which they don't have any opportunity to respond to, if they're put into the public domain, for example, if that's what we're talking about, if it goes into the Public Records Office, for example, people don't have any opportunity, you know, to challenge anything that's said about them, and that's the usual reason. But I mean, whether or not that's a truthful reason is another thing. You know, a lot of these documents are embarrassing to the state, and they don't want them to go out because it would cause political criticism of the government at the time if that's what they related to, and certainly the government of the day doesn't really want that. So I just don't know the detail.
Well, thanks, Peter. That's important to say that. And Richard, you're well aware of people within Haldane who assisted in the miners' strike from a legal perspective and showed legal solidarity. What's your view on this question?
Well, there is no question that there should be a real, meaningful inquiry, not an Inquiries Act inquiry, into the lies that were told about Orgreave. I don't have any question about that. I just want to make a general point about the importance of campaigning, and that is something that if I needed to learn the lesson, I've been taught it by working for Greenpeace for these last 6 years, that you don't just take a case as a lawyer because you think you might win it. You take a case in this kind of context because you can win in the court of public opinion. You don't necessarily get the judges on your side, but by keeping on, you begin to wear them down ultimately when they thought that they could wear us down. So kind of echoes of something inside so strong. I do continue to believe that we will prevail. In the Finucane case, I do believe that the Orgreave folks will prevail. And whether it's a judge that hands you that understanding, or whether it's the people's ultimate decision that the government lie again, we keep on until we get the verdict one way or another. Over.
Thanks, Richard. In that respect, I have another related question which echoes your response, but it comes from another eminent Greenpeace lawyer, Sarah Burton. She asks, do you think it's important to make clear that the refusal to hold a proper public inquiry in this case is something that citizens of the UK should all be concerned about? That is, it's not simply about the Troubles or the North of Ireland, but impacts on all of us and how our government relates to its citizens. How best do you think to make that case? So I think, Richard, you've touched upon it. Peter, do you want to sort of address that wider point, the way in which all citizens within Britain need to be aware of this and how best we make that case?
I think at the moment, I think the one thing that I would sort of try and emphasise is the fact that the government of the day, the Tory government of the UK at the moment, is attempting to limit truth-seeking. There's a review of judicial review being conducted at the moment by, I think it's Lord Foulkes, and he is appointed by the Tory government to review judicial review, and you know, probably as a government response to the criticism from the Supreme Court in a number of cases, and in Pat's case as well. And a review of judicial review means a dilution of judicial review, diluting the strength of judicial review against the state. And recently, I've read that there is going to be a review of the European Convention of Human Rights. There's going to be human rights are going to be under the spotlight, with a government review by someone appointed by the government to determine whether or not the Human Rights Act is being applied properly. I think we all know what that means. That's another attempt, I think, to dilute the provisions of the European courts, various judgments over the years, which it's just something I think should be flagged up and challenged.
Well, luckily enough, Peter, comrades on the Haldane Executive Committee have done that, and we've made a submission in relation to that. I'd like to flag up that Claire Nevin and Margot Monroe-Kerr had an important impact with their drafting of the submission, and I'll post it in the chat so that people can view it at their leisure. But the next question is from an anonymous attendee, and it asks, what should be the remit of a public inquiry? Now, that goes into the territory that we also have explored somewhat. And the question of the scope of public inquiries, the nature of public inquiries, and the intersection between law and politics is key there. But also, there's the question of truth and reconciliation within the north of Ireland as well. So, Richard, can you address that question first, please?
I think we have pretty much covered this ground. The same well, since the person is anonymous, presumably the same anonymous attendee has also raised the question of about the Grenfell inquiry and the evidence about lack of regulations there, and the consistent role or response of those most responsible is to avoid embarrassing questions as much as they can. And the function of a public inquiry is to ask embarrassing questions and get answers to them. And frankly, if those answers are simply denied, if the right to obtain answers is denied, then it is a fundamental attack on our democracy, or what we presume to call our democracy. Others may take issue, but I think that's really all I can say in response to that.
Okay, thanks, Richard. I think, Peter, we've covered that unless you'd wanted to say anything specifically. But Nadine Finch asks, do you think it is useful to raise this campaign, the Pat Finucane campaign, in the context of the Covert Human Intelligence Bill? Now, I'm instructed in relation to the undercover policing inquiry, and one of our vice presidents, John Hendy QC, is now in the House of Lords, and he is campaigning strongly on this issue. But I wonder if you've looked at it, Peter, in the context of Pat's campaign.
Well, the whole question of agents and running agents was a live enough issue during the certainly in the various reviews. It was Corey covered it, Judge Corey covered it, and De Silva covered it, but we didn't get a chance at I don't like to keep making the same point again, but we didn't get any opportunity to have any input into those reviews. So they weren't inquiries in that sense, but there's some documentation produced about the running of agents, and there was this exchange that the people who are running the agents, the military people and the police, were complaining because they had no guidelines in place. So they were sort of dealing with agents off the cuff, so to speak, in an informal way. Now, what looks to me as if it's happening now, this has been put into a formal legislation, which actually gives agents the right, or gives them the go-ahead to commit murder and other crimes if it's appropriate, if it's deemed appropriate. And again, you know, who deems it appropriate? That's the question. Where's the control, and where's the political oversight for that sort of thing? So that's another worrying piece of legislation that's going through the process, the legislative process, and it seems that there's quite a number of these initiatives, let's say, from the government people to change things to suit themselves.
Yes, I think, Peter, my experience of the undercover policing inquiry, which for the information of those present stems from 1968 right through, in effect, the present day, is that the bill that's referred to here is an attempt to preempt the outcome of that inquiry, and the way in which that has, you know, gone through without effective opposition from the leader of the so-called opposition, our former secretary Keir Starmer, is very concerning. John Hendy is doing his best with other lawyers and members of the legislature to highlight the dangers of this bill. But certainly there is grave concern, especially amongst trade unionists who have been blacklisted and spied upon for decades, and family justice campaigns, including the family of the murdered teenager Stephen Lawrence. They were spied upon by the British state while they sought justice. And there's many groups within that undercover policing inquiry who are being denied proper voice. So Richard, I mean, how aware are you of this bill, and what do you think of the process, or do you disagree on my views?
Disagree with your views, Declan? You must be joking. Seriously, I occasionally wonder whether there aren't prizes given to the civil servant who can come up with the most big brother concept new piece of legislation that the government can push through to deny any semblance of responsibility for human rights in this country. It's absolutely appalling that a Home Secretary, a Home Office could be proposing that we should have as limited and restricted forms of sanctioned murder by the state. I mean, that is what we have come to. This, you know, people say that the expression "banana republic" is racist. Well, whatever the non-racist form of a banana republic is, what we are seriously at risk of becoming. And I'm perhaps treating it a bit too lightheartedly, because it really is. It does beg a belief that any serious-minded politician could call themselves a public servant and serve the public this appallingly.
So I think I'd like to read a contribution from a true public servant, Phil Scratton, who says, "The Hillsborough documents were held under the 30-year rule. Andy Burnham pressured Gordon Brown and the period was reduced to 20 years, which enabled the independent panel to be appointed and our access to approximately 2 million documents from over 80 individuals and organizations." And he led the research team that analysed the entire collection, and this access turned the case on its head. And indeed, you know, that's partly my experience in representing the blacklisted workers, the blacklist support group. And when we first took on the case, there was another Haldean lawyer, David Renton, and we were denied disclosure, and that denial of disclosure was the rule behind the rule that was sought to prevent justice. And disclosure in the process of inquiries is crucial. And of course, the 2005 Act has restricted the capacity of disclosure, and it has also restricted the capacity of advocates to cross-examine the nature of that disclosure. So this is why we're looking at the inquiry into inquiries, and we're very grateful for Phil's assistance in that respect. So is there anything in relation to Phil's contribution, Peter, that you would comment upon?
Well, disclosure is very important, because disclosure, you know, disclosure of documentation in particular, disclosure is not the primary documents. They're primary documents that come into any inquiry, and then you've got disclosure of relevant but not primary documents. But how you determine the truth of documents is very important, because you don't know whether, if you're handed a document, it's all very interesting and you can compare it with other documents, that's all very interesting. But if there are conflicts in documents, conflicts in written statements, for example, the only way that you can actually reconcile that is to cross-examine or question the makers of the statements in that sort of situation. So unless, of course, you know, if you agree that the truth is in the statements primarily, you know, and you don't have a problem with what's actually stated in various witness statements, for example, it doesn't arise. But if you're in a situation where you have a serious issue about belief in relation to documentation, you have to have the forensic ability to examine the documents, to examine the original documents, to check signatures, to check handwriting, you know, to make sure, to get experts if necessary, to, if you think there's something not right about particular documents. Because when you get the documents, whatever sort of an inquiry it is, when you get the documents, they have been gone over a number of times by the people who produce the documents to you. So you have to try and determine whether or not these documents have been doctored in some way. And we have the example of that in Pat's case with the FRU, the military handlers who withheld the handwritten contact forms, as they were. These are the communication between Nelson and his handlers, for example. And it seemed clear that they were doctored in some way, and they were sanitized in some way. And they removed any sort of connection between Pat and Nelson and the FRU. And, you know, we had one witness who came forward, who was a member of the FRU, who told us that these documents had been doctored, that they took them away and they removed any sort of contact with Pat and the FRU. And, you know, you have to be able to challenge anything that you don't agree with in any inquiry. It's as simple as that. You may not be, you know, you may not get to the bottom of it, but at least you should have the opportunity to do it. And I don't know about the documentation produced in Hillsborough. I'm not sure about that. I spoke to Phil about it. recently, and I'm not that sure about how they sort of managed the documentation, because it was quite a large tranche of information, and it was very damning, of course, of the people who were responsible for the Hillsborough tragedy. But I think you still have to retain. You have to have the tools, the forensic tools, to be able to challenge documentation.
Thanks, Peter. Richard, do you have anything to add on that point?
Other than my undying admiration for Phil and his incredible work, I had the privilege of working with him on the blanket person inquiry about many of the clients that Pat and Peter were representing at the time of the leading up to the hunger strike. But the only thing this worries me about is coming back to the prizes that I suspect are given for coming up with the nastiest forms of legislation, because I am sure that governments look at these documents that are disclosed and which cause embarrassment and say, to their first question is not what action do we take to stop embarrassments like this occurring in future. Their first reaction is, what action do we take to make sure this never gets out in future? And the first thing you saw in response to the Bloody Sunday inquiry was the Inquiries Act itself, and the constant, Peter mentioned earlier, the constant attacks on the inquiry for taking so long. Yes, it did take too long, for costing so much. Yes, it did cost a lot, but let's never forget, that was one of the few things that we would actually praise Tony Blair for, that I would praise Tony Blair for, that he had the integrity to answer to the demands and create a really genuine public inquiry. And you can just bet your bottom dollar, cent, whatever, that those ministers responsible afterwards said, never again. What do we do to make sure that this is never going to happen again? Thanks, Phil.
Well, I think that's right, Richard, and the way in which Deepa raises the question in relation to Julian Assange, I think is relevant there to some degree as well. He sought to bring to light the war crimes in Iraq, and he is suffering ever since. The question which I suggest will be the final question comes from Sam Weinstein. I think Sam is a lady. She says, thanks for all your contributions. We have learned a lot tonight. A number of us at Women Against Rape and Payday and other grassroots organisations have been campaigning against the CHIS Spy Cops bill that we've been referring to, which Michael mentioned as one reason to continue campaigning for justice for Pat Finucane. We're trying to gather public support to show the Lords that the public is very opposed. It's a very dangerous move to sanction, legalise and cover up serious crimes, including rape and murder by state agents. Are any of the speakers' lawyers actively campaigning with this bill or the Overseas Operations Bill who we can be put in touch with? So Sam, yes, I think as we alluded to, there are many Haldean lawyers involved in these campaigns. As an executive committee, we are very much supportive of all our members involved, including those on the executive committee and our vice presidents. And as I alluded to, John Hendy is masquerading as a lord for the purposes of such campaigns, and to have access to those very debates. And we as a society will continue to highlight all of that. But I think it's important to highlight this point, Richard and Peter, because certainly the nature of capitalism has long ensured discrimination against women in society has been maintained through patriarchy, through the way in which the monarchy impacts upon the constitution, and the way in which that manifests at all levels and all institutions. So when Sam raises the question of women against rape, there's an important point there. The way, I think, Richard in particular, you've had many experiences as a criminal advocate, as has Peter. So if you could maybe try to address that final question in the way in which you think most appropriate, and try and bring it back to have a few concluding remarks upon the Pat Finucane campaign. So Peter, if you would like to go first.
Well, we had a review of in Belfast. There's a review of the rape trials and the provisions that apply in rape trials, mainly in relation to anonymity, and compared with South, the Republic. And a report was prepared by one of our Court of Appeal judges, John Gillan, who was actually a judge sitting in an appeal in the Court of Appeal in Pat's case. So he did a fact-finding review of various jurisdictions in relation to how these cases are treated in the courts. And he came up with a fairly comprehensive report, which is fairly lengthy, but I think worth reading. It's called the Gillan Review. Straightforward, you can Google it, and it covers a lot of different issues, and made quite a number of interesting recommendations.
So, thanks, Peter. Richard, do you want to address that, and perhaps give a sort of summing up to all those who are attending, please?
Well, to Sam's question, I'm very grateful to her for asking it, because I joined the Haldane Society 47 years ago, which is a pretty terrifying thought for me. But one of the first things I discovered was that it's your society. It's not run by any clique. It's a very open, in its attitude towards what socialism is. There is no a political correctness test that has to be undergone by anybody who joins. You join, you get in, you get stuck in, and you help to write the reports, you help to lobby the members of the legislature, you help to organize demonstrations, and so from that point of view, I would just say, Sam, if you're not already in the Haldane Society, and you probably are, but the executive committee, in my experience, is made up of anybody who says, I want to be on the executive committee. It is not an exclusive club, and anybody who wants to work, wants to get stuck in, is asked to do so, and welcomed with open arms. So, and yes, we do have our very own member of the House of Lords in the form of John Hendy. We don't usually have many of them, but we don't exclude them either. John is one of the greatest long-lived campaigners and comrades, and certainly my first days at the bar. So yeah, we will support you. You will support us, and we definitely want to do everything we can to kill this Chiz Spy Cops bill. Rounding things off from my own side, I've got this little list of participants, and 40 of you still have the determination to stick it out and listen to us whittling on all this time. And I am so thrilled to see many friends from the United States who have joined us and who I've worked with for decades. And I'm not going to embarrass you by calling your names. And members of Pat Finucane's family who have joined us for this. We're absolutely thrilled to have you with us. I think it is so important that we are keeping on. That Peter, indefatigable, barely begins to describe how you have your heart and soul. Well, I think you have a soul. Your heart has been in this since the very beginning. I know I can never resist the chance to have a go at Peter. It's part of our tradition. But no, I love you, and I thank you for all that you continue to do for the family, who are the most wonderful people in the world. And thank you, Declan, for pulling us all together.
Well, I'd just like to pay tribute again to Peter and Richard, as Richard has echoed the introduction to Peter, and I won't embarrass him too much, but you know, I have been aware of his work from my teenage years through my early years in practice, and Richard similarly has been an important influence in my legal and political thoughts, and we've crossed paths in different countries for different reasons at different times, and you know, I'm grateful for his support in attending tonight and being the advocate for the family in this situation, and for representing Haldanes so well. So just now I will conclude with a sort of reiteration of what Richard has said to Sam. I would emphasize that the Haldane Society of Socialist Lawyers very much takes its role and its obligation as political observers very, very seriously. We have a responsibility as socialists, we have a responsibility as lawyers, and to combine socialism and lawyering, we take these responsibilities very, very seriously, and we want to continue to grow as a society, to utilize our collectivity, our links with the trade union movement, with family justice campaigns, and indeed, as Richard and another advocate for Hannah Yamin said at our AGM this year, we need system change for climate justice. So the two big projects next year for the Haldane Society will be the inquiry into inquiries, which covers a lot of these issues, and where we will continue to lend our support to the Finucane campaign, to the Orgreave Truth and Justice campaign, and to scrutinise and to hold to account the undercover policing inquiry and the Grenfell inquiry. And the other big project will relate to the forthcoming conference in Glasgow, which is known as COP26, where the Paris Agreement will be scrutinised, and the countries involved will be held to account, not by those necessarily inside the conference, but by the people on the streets, including the trade union movement, including the Haldane Society, and including the International Association of Democratic Lawyers, who are preparing a report and will assist those on the street to make the point known for those inside the conference. So I was just wondering if Richard wanted to intervene there with any sort of comments. I thought he was maybe itching to say something. No.
No, you've heard too much from me already, Declan.
Okay.
Let's do that another time.
Yes. Well, just that all I would say is I posted in the chat the website to join the Haldane Society, so we're very welcoming and we're non-hierarchical. And I joined as a student, and Richard persuaded me within a year to be the treasurer, and you know, that's the way things work. We want to pass on the flame and encourage those who are starting their careers that you know, there can be a better society, and as a society we would very much like to be part of that. So thanks to everyone for attending, and we will end the meeting within the next 10 seconds. So everyone have a peaceful and safe time during the holiday period, and solidarity to the Finucane family and to all those fighting for justice.